Good afternoon all. Welcome to Nirnay IAS. In this session we are going to discuss very valuable and important multiple choice questions for prelims. Good afternoon all. Good afternoon. Good afternoon. In this session, we are going to discuss very valuable, important, multiple choice questions for prelims. So, starting with the first question, Article 201. Good afternoon all. Article 201. Now it has been in news because of Supreme Court imposing time restriction on President's approval for the state bill that has been reserved by the Governor. So Article 201 deals with which one among following factors? Any one of you. Veto power of the Governor, or the veto power of the President with regard to parliamentary bill, President's veto power with regard to state bills reserved by the Governor. Which one is correct? The option C is correct. Option C is correct. Always remember, Governor can give his assent, or he can send the state bill for the reconsideration of State Assembly, or he can reserve that state bill for the consideration of the President under Article 200. Once the Governor of a state has reserved a state bill for the consideration of the President, President deciding upon such bill is enshrined in Article 201. In the examination, all in the pressure, under the grip of examination pressure, do not confuse yourself with Article 200 and Article 201. And one more thing, you should be able to distinguish between Article 201 on one hand, Article 111 is on the other hand. That is why I chose both the articles to discuss with you. And this is the greatness of Nirnay IAS. We teach every vital fact, minute fact, elaborately and lucidly, so that it would be embedded in the minds of the aspirants. So here the answer is C. Next, Article 111 deals with Governor's veto powers, President's veto powers with regard to state bill reserved by the Governor, President's clemency powers, President's veto powers with regard to parliamentary bills. Here the right answer is President's veto power with regard to state bills reserved by the Governor. It is reserved by the Governor. Hence, always remember, we should be able to distinguish between President deciding upon state bill that has been reserved by the Governor. Then, one more thing, President deciding upon parliamentary bills President deciding upon parliamentary bills comes under Article 111. One more important fact I would like to add here. The President of India has absolute veto powers only on two categories of bills. The President of India has absolute veto powers. Absolute veto powers only on two categories of bills. One is a private member bill. That means a bill that has been introduced by a non-minister in parliament. A private member bill. Second, a state bill reserved by the governor. A state bill reserved by the governor. For the consideration of the president. For the consideration of the president. This is very, very important because UPSC, it might not be directly asking Article 201, Article 200, but it might be asking the associated facts which are associated with the main topic. The main topic is governor, the main issue, governor reserving state bill that has been duly passed by assembly for the consideration of the president. Then president deciding upon such bill under Article 201. These are the main issues which have been in current affairs. But UPSC is very shrewd. Most of the times it might not be asking directly the issues that are involved in current events. It might be asking the corollary factors, such as on which types of bills or on which categories of bills the President of India has absolute veto power. What does absolute veto power mean? The President can summarily reject them. There are only two categories of such bills. One is a private member bill introduced in the parliament, and the other is a state bill that has been reserved by the governor for the consideration of the president. And one more thing, friends, one more thing, my dear aspirants, under Article 200, one state bill has to be compulsorily reserved by the governor for the consideration of the president. Compulsorily. What is that? If a state bill undermines, if a state bill undermines the authority or jurisdiction of the High Court, the authority or jurisdiction of the High Court concerned, that means if Telangana legislature passes a bill undermining the authority of Telangana High Court for Telangana, the governor of Telangana has to compulsorily reserve that bill for the consideration of the president. Has to compulsorily reserve that bill for the consideration of the president. So this is Article 201, Article 111. Article 201 and Article 111. Next question. Article 31B deals with. This is very, very important because recently the Supreme Court pronounced that the material resources does not include all the material resources. It includes only such private resources which have public significance. Anyhow, before delving deep into the topic, what is the answer? Article 39B deals with which one among the following? Equitable distribution of material resources of the nation, prevention of concentration of means of production, uniform civil code, protection of environment. Which one is correct? Any one of you? Any one of you? Which one is correct? Which one is correct? Which one is correct? Option A is correct. It is one of the DPSPs which deals with equitable distribution of material resources of the nation. Earlier, the Supreme Court pronounced any resource, whether it is governmental assets or natural resources like mineral blocks, forest produce, or governmental assets like the electricity, production of electricity by governmental agencies like NTPC, or the benefits that are given by the government, even private resources, that means the movable, immovable assets owned by the private people also come under the definition of material resources of the community. Material resources, simply they mean movable and immovable assets. Earlier, the Supreme Court of India enunciated material resources include both movable and immovable assets owned either by the government or by a private individual or a natural resource like mineral block. But recently the Supreme Court pronounced only anyhow governmental, the movable, immovable assets of government, they come under the resources of community. The natural resources of the nation, they also come under the definition of material resources of the community. The issue is related to, here the contentious issue is, the bone of contention is, if I were to have a costly watch which worth 50,000 rupees, will it also come under the definition of material resources of the community? Earlier in its judgment, Supreme Court pronounced even the cash that is held by a private individual, a gold ornament, a movable property like a vehicle, even a costly or luxury watch, everything comes under the definition of material resources of the community. But recently the Supreme Court pronounced only those private assets which have public significance, they only come under the definition of material resources of the community. That means I am running a group of educational institutions. They come under the definition of material resources of the community. Those educational institutions which have been running can be nationalized by the government by making a law, or the fee can be reduced by the government. Such measures can be taken. Or if I were to own a corporation which generates electricity, like Adani Group has a corporation which generates electricity in Godda district in Jharkhand, which supplies electricity to Bangladesh. Only such assets owned by private individuals which have public significance, they only come under the definition of material resources of the community. This is what pronounced by the Supreme Court of India recently. In this light, this DPSP assumes significance. In this light, this DPSP assumes significance. Environmental rights come under which category of fundamental rights? First generation rights, socio-economic rights, or second generation rights, or third generation rights? Because last year, March, the Supreme Court of India enunciated right against the baneful effects of environmental degradation are one of the fundamental rights under Article 14 and 21. Right against baneful effects of environmental degradation is one of the fundamental rights under Article 14 and 21. Article 14 and 21. So, in this light, the UPSC might ask the question with related to what are first generation rights, what are second generation rights, what are third generation rights. First generation rights are civic rights as well as political rights. Civic rights and political rights. Civic rights are related to freedom of body movement or freedom of mental realm, freedom at mental realm. Like example, right to freedom of speech and expression. Right to freedom of speech and expression. Right to freedom of speech and expression. Second, right to movement. Right to movement under Article 19, subclass D. Right to freedom of speech and expression. They are called any right related to our physical freedom or psychological freedom. They are termed as civic rights. What are political rights? Right to participate in governance. Right to participate in governance. Example, RTI Act, right to vote, They are considered to be political rights. They are considered to be political rights. Then second, these are first generation rights. First generation rights, they are of liberal origin. Socio-economic rights, they are called second generation rights. They are socialist origin. These second generation rights are socio-economic. They are socio-economic, such as right to work, right to education, right to education, right to education, etc. They are second generation rights. Third generation rights, the uniqueness of third generation rights is that they belong to the entire community. Entire community. They belong to the entire community. They belong to entire community. Like multicultural rights. Multicultural rights. Multicultural rights, environmental rights. They are considered to be third generation rights. In the light of Supreme Court's judgment, the right against baneful impacts of environmental degradation, because environmental rights are part and parcel of third generation rights. Hence, such type of question can be asked by UPSC. This type of question can be asked by UPSC. It can be asked by UPSC. In the light of recent Supreme Court's judgment, right against baneful impacts of environmental degradation is one of the fundamental rights under Article 49-21. 49-21. Article 49-21. So, in that light, this question can be asked. Next question. Article 324 subclass 2 deals with. This is very, very important. Because in 2023, what happened? First of all, we will examine the answer. What is the answer? Any one of you? Can you guess what is the answer for this question? Can you guess the answer for this question? Article 324 subclass 2 deals with the duties and functions of Election Commission, right to vote, right to be incorporated in the electoral rolls, the manner of appointment of Chief Election Commissioner and other election commissioners. This is the right answer. Answer D is the right answer. No, not at all. That is why I asked the question. The right answer, the manner of appointment of Chief Election Commissioner and other election commissioners. Why it is so important? Always remember, my dear aspirants, the questions that are asked based on current affairs, especially in subjects like polity, UPSC has a specific approach. Any polity related question on current affairs, generally it will have two characteristics. One is the mainstream media should have distorted the constitutional fact. Second, most probably union government is right according to the constitution. So in this regard, why this specific question is potentially important for upcoming prelims? The mainstream media distorted this fact. Actually, according to the constitution under Article 324 subclass 2, the Chief Election Commissioner and other election commissioners will be appointed in such manner prescribed by the Parliament by making a law. The truth is that till 2023, there was no parliamentary law on the mode of appointment of Chief Election Commissioner and other election commissioners. Hence, the Chief Election Commissioner and other election commissioners used to be appointed by the President purely on the advice tendered by Council of Ministers headed by Prime Minister. There was no law on the manner of appointment of Chief Election Commissioner and other election commissioners till 2023. When there exists lacuna or vacuum because of lack of law or because of executive policy, the Supreme Court can lay guidelines under Article 32, under Article 142, under Article 141. This is what Supreme Court enunciated in Vineet Narayan case when it laid down guidelines with regard to the appointment of the Chief of CBI. In 2023, since there was lack of parliamentary law on the manner of appointment of Chief Election Commissioner and other election commissioners, the Supreme Court under Article 142 and Article 32, it laid down guidelines with regard to the appointment of Chief Election Commissioner and other election commissioners. Later on, somewhere in November or December of 2023, the Parliament, by invoking this Article 324 subclass 2, it laid down the procedure of appointment of Chief Election Commissioner and other election commissioners. Now it is challenged in Supreme Court. The case has been pending before Supreme Court, but the Union government is going to win the case because the Constitution of India clearly laid down the manner of appointment of Chief Election Commissioner and other election commissioners purely determined by a law made by the Parliament. But mainstream media, it distorts the facts as if till 2023, the Chief Election Commissioner and other election commissioners used to be appointed by the President on the recommendations of a high-level committee headed by Prime Minister, Chief Justice of India, and Leader of Opposition. It was totally wrong. It's a blatant lie. Till 2023, till the Supreme Court laid down guidelines in this regard, Chief Election Commissioner and other election commissioners used to be purely appointed on the advice of Council of Ministers headed by Prime Minister. So this is the constitutional truth. My dear aspirants, I am vehemently urging you to focus on constitutional truths. Don't be carried away by the propaganda perpetrated by unscrupulous media houses. You purely base your preparation on constitutional truths. So this is Article 324 subclass 2. Then Article 329 subclass B deals with, what is the answer according to you? What is the answer? What is the answer? What is the answer? What is the answer for this question? Any one of you? Yes, exactly correct. Right to move the High Court with regard to the election of MPs and MLAs, MLCs. It is an election petition. It is one of the legal or constitutional right. It's a legal or a constitutional right. It's a legal or a constitutional right. As we know, all the rights that have been enshrined in Part 3 of the Constitution, they are fundamental rights. The remaining rights that have been enshrined outside Part 3 of the Constitution, they are called constitutional or legal rights. This is one of the constitutional or legal right. This is one of the constitutional or legal right. Then comes reservations for Anglo-Indians have been removed by which constitutional amendment act? Reservations for Anglo-Indians have been removed by which constitutional amendment act? Exactly correct. Exactly correct. 104th Constitutional Amendment Act. 104th Constitutional Amendment Act. Now, Article 26 deals with, this is very, very important, it assumes significance. Article 26 deals with, what is the right answer? Freedom of religion of an individual, rights of minority educational institutions, rights of religious denomination institutions, right against religious instruction in certain educational institutions. Which one is correct? Which one is correct? Only Reshav Verma is answering the questions. Any one of you? Which one is correct? Yes, you are exactly correct. Article 26, it deals with the rights of religious denominational institutions. It deals with the rights of religious denominational institutions. This fundamental right assumes significance in the light of Supreme Court's judgment with regard to Aligarh Muslim University. Recently, the Supreme Court delivered its judgment with regard to minority educational institution status to Muslim Aligarh Muslim University. So this is Article 26. Then what is Article 30? What is Article 30? What is Article 30? Rights of minority educational institutions. Exactly correct. Rights of minority educational institutions. Then what is the difference between religious denominational institutions and minority educational institutions. There is a minute difference between religious denominational institutions on one hand, minority educational institutions on the other. What is that minute difference? What is that minute difference? Religious denominational institutions means the educational institutions that are run by Ramakrishna Mission. Ramakrishna Mission is a religious denominational institution. The educational institutions that are run by Tirumala Tirupati Devasthanam, they are religious denominational educational institutions. The educational institutions run by missionaries of charity established by Mother Teresa, they are religious denominational institutions. The educational institutions that are run by Dayananda Saraswati Trust, DAV schools, what we say, they are religious denomination educational institutions. Then what do minority educational institutions, religious denominational educational institutions? They fall under the ambit of Article 26. Of course, all the rights that are available under Article 26, they are also available under Article 30. Then what do minority educational institutions mean? The medical colleges, engineering colleges that are run by OIC brothers in Hyderabad, they fall under the ambit of minority educational institutions. Here in this slide, I would like to emphasize on Article 31 capital A, which has been incorporated by 44th Constitutional Amendment Act. Which has been incorporated by 44th Constitutional Amendment Act. So, according to this article, if the government is going to take away the property of religious educational institutions, government has to pay the full compensation, market compensation. That means Telangana government or the union government of India is going to take the assets of the educational institutions that are run by OIC brothers or Shadan College in Hyderabad. These are minority educational institutions. For any public purpose, for metro rail project or laying highway or for railway projects, the government has to pay market price, full compensation. But same Telangana government is going to take away the property of Ramakrishna Mission or Ramakrishna Mutt in Domalguda, Hyderabad. Government need not to pay adequate compensation. Even if it pays 100 rupees, that cannot be questioned in the court of law. So this specific right is available for minority educational institutions. That is why I am discussing all these facts, because recently there was an issue with regard to Aligarh Muslim University, whether it has the status of minority educational institution or not. Earlier, the Supreme Court enunciated Aligarh Muslim University did not have minority educational institution status, because in order to be included under the ambit of Article 26 or Article 30, the words established and run, both these words establish and running, should be read and interpreted conjunctively. That means the group of people who have been running that educational institution, they should have established the same. But with regard to Aligarh Muslim University, it was established formally by British government by legislating a parliamentary law. Hence, earlier Supreme Court ruled it didn't have minority educational institution status. But recently the Supreme Court enunciated it does have the status of minority educational institution because Aligarh Muslim University, it had its prototype college which was established by Sir Syed Ahmad Khan. So what was the purpose behind the establishment of that college by Syed Ahmad Khan? Who were the financial contributors to establish that college? What were their intentions and objectives? In order to ascertain their intentions and objectives, the communication, the correspondence amongst them should be understood. So they established that educational institution to modernize Muslim youth, to incorporate modern science education amongst Muslim youth. This was the objective. Later, the British government, by legislating a law, established Aligarh Muslim University. In total, the Supreme Court, in a nutshell, declared that Aligarh Muslim University does have minority educational institution status because it should not be understood only from the perspective of formal establishment of that organization. The roots of that university should be traced. What are the benefits if any educational institution were to be declared as minority educational institution? This one. And apart from that, if the educational institution which is minority educational institution has not been getting benefit out of governmental funds, it can reserve total its seats for minorities. And even if it gets a little bit of financial aid from the government, large chunk of seats can be reserved for only minorities. So regulation of the government will be minimal on that educational institution which has the status of minority educational institution. Next, which one among the following DPSPs deals with protection of environment? What is the right answer? What is the right answer? What is the right answer? C. C. Exactly correct. C. C. Always remember, all the directive principles of state policies that have been incorporated by constitutional amendment acts are very, very, very important. All the directive principles of state policy that have been incorporated by constitutional amendment acts, very, very important, I am cautioning you. And which new directive principle of state policy has been incorporated by which amendment act is very, very important. For instance, this one is incorporated by 97th Amendment Act. This has been incorporated by 97th Amendment Act. As I told you, last year's Supreme Court's judgment, right against baneful effects of environmental degradation, is one of the fundamental rights under Article 14 and 21. In that light, this question can be asked. Article 341 deals with Article 341 deals with yes, exactly correct. STs, notification of STs under Article 242. Notification of STs is under Article 242. So recently, Supreme Court, it has upheld subcategorization of SCs. That means scheduled caste can be subdivided into various categories so that the most backward communities amongst scheduled caste could get more reservation. They could get more reservation. They could get more reservation. They could get more reservation. So this is question number 14, that is Article 341. Then Article 361 deals with, which one is right answer with regard to Article 361? What is the right answer? And why it assumes significance? That also you should tell me. It is current, it's a current related question. Always remember, the aspirants commit one blunder, thinking that they can give adequate answers to current based questions without having deep roots in the core subject. No, do not have such kind of misconception. You will be able to give adequate answers to current based questions only when you have deep insights into the core subject. This is the greatness of Nirnay IAS, which allows the faculty, which enjoins the faculty to incorporate and to inculcate deep insights into the core subject amongst the aspirants. Like, I am deeply indebted to Nirnay IAS. I am thankful to Nirnay IAS. Nirnay IAS is allowing me to teach polity from this book, The Constitutional Law by MP Jain, which is referred by judges of Supreme Court and High Court. That is why what we teach in Nirnay IAS, we teach from the depths of the subject. By this time, by watching video, by this time you might have got conviction that the quality of teaching in Nirnay IAS. Yeah. What is the right answer? Article 361 deals with governor's clemency powers, governor receiving the state bill, reserving the state bill. I'm extremely sorry. It's a typing mistake. Reserving state bill. State bill for the consideration of the president. Governor's functions with regard to adjoining union territory. Governor's immunity against arrest and criminal proceedings. Yes. Option D is right. Why option D is right? Why option D is right? Why? First of all, we will discuss the President of India and governors of states. Governors of states are not answerable for any court of law. Any court of law for the performance of their duties and functions. For the performance of their duties and functions. For the performance of their duties and functions. And no criminal proceedings, no arrest warrant can be issued against them. No criminal proceedings. And arrest warrant can be issued against them. Can be issued against them. So how come this article assumed significance? How it is related to current affairs in polity? How it is related to current affairs in polity? How it is related to current affairs in polity? How it is related to current affairs in polity? Why it is related to current affairs and polity? Any one of you? No, not at all. Last year, a female employee in West Bengal Raj Bhavan, that means a female employee in West Bengal's governor's office, that is called Raj Bhavan, she alleged sexual harassment complaint against the governor of West Bengal. In that light, this article assumed significance. No criminal case can be opened against the governor. No arrest warrant can be issued against the governor. This situation also arose in the light of accusations against then Governor of Madhya Pradesh in Vapam scam. So as long as they are in the office, both president and governors are in the office, no criminal case can be filed against them, no arrest warrant can be issued against them. In this light, Article 361 assumes significance. In this light, Article 361 assumes significance. Understood? Then Article 142. Now Article 142 has become very well known because recently Vice President of India condemned this Article 142. But of course, by that time the question paper might have been prepared for prelims because Vice President's remarks were very recent, just 3 weeks back or so. So by that time, UPSC question paper might have that might has been prepared. Hence, this can be asked. Under Article 142, the Supreme Court of India has wide amplitude of powers, widest amplitude of powers. It can issue any order or decree to do complete justice. Simply under Article 142, the decisions that can be taken by a speaker, the decision that can be taken by a chief minister, the decision that can be taken by the vice president can directly be taken by the Supreme Court. It can issue any order or decree. It can issue any order or decree to do complete justice. In recent times, within these 2 years or 1.5 years, so the Supreme Court invoked this article many times. It invoked this article many times. It invoked this article many times. The remarkable case, an MLA in Manipur Assembly, he won the seat on Congress party ticket. Then he defected to ruling BJP. He got the portfolio of tribal welfare minister. Then the Congress party filed petition with Speaker of Manipur Assembly to take action against that MLA who won elections on Congress party ticket. The Speaker did not react. They went to High Court of Manipur. High Court of Manipur, it exhorted the Speaker of Manipur Assembly to take a swift action. Despite the Speaker did not act. Then the case went to Supreme Court. Supreme Court issued 2-3 the time limit for the Speaker to act upon the case. Even then the Speaker did not react. Then the Honorable Supreme Court of India directly invoked Article 142 and it removed that MLA from the primary membership of Manipur Assembly. That means invariably he lost tribal welfare minister portfolio as well. Then another case, the convicts in Rajiv Gandhi assassination, they filed mercy petition to the governor of Tamil Nadu under Article 161. The Supreme Court of India and many high courts in our country, they pronounced the president under Article 72, the governor under Article 161, when they exercise their clemency powers, they have to exercise their clemency powers only on the advice of their respective council of ministers. In this case, the governor of Tamil Nadu, he referred that mercy petition filed by the convicts in Rajiv Gandhi assassination for the consideration of the president, which is not allowed by the constitution. The case went to Supreme Court. Supreme Court admonished the Attorney General, the Union government, and Supreme Court, by invoking again this Article 142, it directly set the convicts in Rajiv Gandhi assassination free. So that is the power of Article 142. In Goa, a serving IAS officer had been appointed as the State Election Commissioner. The Honorable Supreme Court of India, by invoking Article 142, directly removed that IAS officer from the post of State Election Commissioner. 2 years back, the Honorable Supreme Court of India under Article 142 declared voluntary prostitution either by a girl or a woman is not a criminal act. This is how this Article 142 has been invoked by the Supreme Court in recent times, in many cases. So here the right answer is to issue orders or decree to do complete justice. To issue orders or decree to do complete justice. Review petition can be filed under. What is the right answer for this question? What is the right answer for this question? What is the right answer for question number 14? Exactly correct. Article 137. Article 137. Article 137. Article 218 deals with. Article 218 deals with exactly correct. The provisions of the Supreme Court that are applicable to High Court also. So what are the provisions of High Court that, what are the provisions of Supreme Court that are applicable to High Court as well? What are those provisions? What are those provisions of Supreme Court that are applicable to High Courts as a matter of court under as a matter of course under Article 218? No. Article 121. The behavior and conduct of judges. Behavior and conduct of judges. Cannot be discussed in the parliament. Judges of Supreme Court, except on removal motion. Except on removal motion. Same article is available under, same provision is available under Article 211 for High Court judges. For High Court judges. Why this article is so important? Because recently the opposition parties, they sought to introduce an impeachment motion against one of the judges of Allahabad High Court who delivered a controversial speech in the very premises of the High Court concerned. That is one case. The other case, recently, as we know, the burnt stacks of cash were found in the official residence of one of the judges of Delhi High Court. So, in these two instances, the members of parliament wanted to discuss their behavior in the house, but without introducing the removal motion against that particular judge, the behavior of that judge cannot be discussed. One more article related to this. Article 124 subclass 2. The removal of a judge of Supreme Court. Same is for, the same procedure is mentioned for same procedure. Removal of judge of a high court. Removal of a judge of high court. So, in this light, these two provisions are similar, both for Supreme Court as well as High Court. And Article 218 mentions there are certain provisions which are commonly applicable both for Supreme Court as well as High Court. So, these articles are very, very important, very, very important. As I told you, the UPSC might not be asking the main issue which is in current affairs. It might ask the corollary things that are associated with the main aspect which is in current affairs. So this is how you have to prepare for current based questions comprehensively. This is how you can prepare for current based questions comprehensively. Mission Karmayogi deals with, which one is correct answer for this question? What is the right answer for this question? What is the right answer for this question? What is the right answer for this question? Yes, this is the right answer. The union government is very serious about enhancing the capacity of public administrators and rigorous performance appraisal. Unfortunately, till recent times, performance appraisal of government officials, especially those government officials who are at the top echelons of bureaucracy, has been totally neglected. In-service training has been treated as holiday trip. Forget about in-service training, even induction training was also not so serious. That is why the union government introduced this scheme, Mission Karmayogi, under which there will be emphasis on capacity building of public administrators and rigorous performance appraisal of public administrators. Article 17. Which one among the following features is not common with the introduction and passage of money bill under Article 110 and that of financial bill under Article 17 subclass 1? So which one is correct? Which one is the right answer? Exactly correct. UPSC often it has been asking questions based on money bill, the differences between money bill, financial bill type A, and financial bill under Article 117 subclass 3. What is money bill? The bill which comprises exclusively of the provisions which are enshrined in Article 110. Money bill is that bill which exclusively comprises all or any or one of the provisions that are mentioned in Article 110. I repeat again, exclusively. That means only the matters that are enshrined in Article 110, like imposing any tax or reduction of any tax, like that. And the procedure of introducing and passing money bill is enshrined in Article 109. The definition of money bill is under Article 110. The procedure of introduction and passage of money bill is under Article 109. 109. Then what is financial bill under Article 117 subclass 1? Financial bill under Article 117 subclass 1 is the one in addition to the matters that are enshrined in Article 110. The bill under Article 117 subclass 1 also contains any matter of general legislation. That means bifurcation of Telangana. In addition to bifurcation of Telangana, you will have any matter mentioned in Article 110. In addition to bifurcation of Telangana, any matter in Article 110. That is financial bill under Article 117. which comprises any matter in Article 110 in addition to any matter of general legislation. In addition to any matter of general legislation. Any matter of general legislation. And Article 117 subclass 3, withdrawal of money from Consolidated Fund of India. Then what is the right answer for this? What is the right answer for this? What is the right answer for 18th question? Yeah. Exactly correct. A is right answer. So what is the difference? What is the difference between introduction of financial bill under Article 117 subclass 1 and introduction of appropriation bill or financial bill type B? Yeah, I am fine. I am fine. I am fine, Prakash Dwivedi. So what is the difference between financial bill under Article 117 subclass 1 being introduced in Parliament, and what is the difference between financial bill under Article 117 subclass 3 being introduced in the Parliament? What is the difference? What is the difference between both of them with regard to their introduction in Parliament? Financial bill under Article 117 subclass 1 should be introduced in either House of Parliament only with the prior assent of the President. Without the prior assent of the President, financial bill under Article 117 subclass 1 cannot be introduced. But on the other, financial bill under Article 117 subclass 3 can be introduced in either House of Parliament even without the prior assent of the President. But before it got approved by the originating house means the house in which the bill has been introduced, before it got assent or it got approved by the originating house, it should get the assent from the President of India. Before that, it should get the assent from the President of India. Before that, it should get the assent from the President of India. So that is the minute difference. UPSC focuses on such minute differences, minute facts. You have to be very careful. This is the uniqueness of Nirnay IAS. We emphasize first on inculcating deep insights into the subject amongst the aspirants. Second, lucid explanation of the concepts. Third, comparing and contrasting apparently similarly looking facts or phenomena. That is the uniqueness of Nirnay IAS. Article 19, 19th question. 19th question. Prakash Dwivedi. Acha. Yeah, sir. You are from Bhopal. You are from Bhopal, I know. Yeah. What is the right answer? What is the right answer? It's a tricky question. Why I asked this question? I will explain. It has significance in the light of current events. This article has significance in the light of current events. Of course, you might type in artificial intelligence or Google, and by this time you might have got the answer. So the answer is the state government has to exercise its executive powers in consonance with the laws made by Parliament. So why this article assumes significance? Why this article assumes significance? Why this article assumes significance? Yeah, D is right answer. Answer is D. So why, how come it related to current events? How come it related to current events? Because some state governments, some chief ministers of some states, for their sheer political mileage, they say that I am not going to implement this parliamentary law. Chief ministers or state government, they do not have even an iota of authority to say that we won't implement the law made by Parliament. It is against the Constitution and it is one of the penal provisions of the Constitution. If any state government refuses to enforce parliamentary law or a law made by Parliament, the union government can issue executive instruction to that particular state government. Despite of those executive instructions, if the state government continues not to implement that parliamentary law, Article 365 says it can be construed the constitutional machinery has failed in the state concerned. That means in that state which refuses to enforce a law made by Parliament, the union government can issue executive direction asking the state government to implement that particular parliament law. Despite of that, the state government concerned does not implement that parliamentary law. According to Article 365, constitutional machinery in the state failed. What does it imply? It implies President rule can be imposed. 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 So this is Article 256. Then question number 20. Under which one of the articles the Parliament can legislate on state subject to enforce international agreement or international covenant? Or international convention. International convention. What is the right answer? Article 253. Yes, exactly correct. Article 253. So, any law made by Parliament, the law made by Parliament under this article can be passed with simple majority. Simple majority. Like the media distorts the facts that particular state government is not accepting this aspect of foreign policy. That means the government of India might be having an agreement with Bangladesh with regard to sharing of Teesta river waters. So without the approval of West Bengal government, it cannot be implemented. This is what the misconception that is spread by mainstream media, which is blatantly wrong. It's a blatant, what you say? It's a blatant lie. Any international agreement of government of India with a single foreign country, a group of foreign countries, or with any international forum or international organization, international forum such as BIMSTEC, international organization like UN, the Parliament can legislate on state subjects such as public order, such as land, such as water, etc. So always I caution my dear aspirants, the constitutional facts, constitutional truths, which are distorted by mainstream media, there are lots of probability that such constitutional truths that have been distorted by mainstream media can be asked in the exam. Glaring example, deployment of central security forces without the consent of the state government. It has been asked twice or so in mains. Then, with regard to the administration of National Capital Territory of Delhi, it also has been asked. Article 16 subclass 4 was asked in 2003. Why Article 16 subclass 4 was specifically asked in 2003? In that year, just 2-3 months before the prelims, the Supreme Court has upheld EWS reservation. The mainstream media distorts the fact that 10% EWS reservation that is given to economically backward community was it is under Article 16 subclass 4. Hence, by deducting 10% from 50% of reservations that are meant for backward communities, the reservation is given to EW, economically weaker sections. That is totally wrong. EWS reservation falls out of Article 16 subclass 4. EWS reservation has been given out of Article 16 subclass 4. Article 16 subclass 4 comprises the 50% reservation which is meant for backward communities, SCs, STs and OBCs. Without taking away even an iota of reservation for these communities, EWS reservation given out of Article 16 subclass 4. But it is shown the other way around. This is where the aspirants have to be very cautious. And this is where the UPSC has been asking the questions, both in prelims as well as mains, if you observe the PYQs. If you observe the PYQs. Now, what is the answer for this? This is also not been emphasized by many institutions, including the so-called reputed institutions. आप ओल्ड राजेंद्र नगर में और मुखर्जी नगर में छप्पा छप्पा छान मारिए, आपको ऐसी मटेरियल नहीं मिलेगी. You will not get such standard material, such standard discussion, such standard facts. प्रकाश जी, यू आर जीनियस. आई थिंक आप गूगल माता से पूछ रहे हैं या एआई से ले रहे हैं, बट यू आर करेक्ट. आर्टिकल 275. नाउ कमिंग टू द क्वेश्चन, हाउ कम इट इज रिलेटेड टू current affairs? That is a tricky question. Now, Rishabh Verma and Prakash ji, this is a tricky question. which cannot be answered by your Google Math or artificial intelligence. In what way it got to do with current affairs? you read my notes. So, प्रकाश जी के सिवा कोई भी ये सवाल आंसर कर सकते हैं? How come it is related to current affairs? No, the thing is that some regional parties, you forget about politics. Some sections in political realm, for their own vested interest, they have been spreading blatant lies. Union government has been discriminating against South Indian states arbitrarily. Majorly, the funds are given by the union government to states under three heads. One is this. So, what is this Article 275? Article 275, it empowers the union government to give grants in aid, fiscal grants in aid. That means union government gives grants to states to reduce their fiscal deficits. Under this article, the union government gives fiscal grants in aid to states to reduce, to fill their fiscal deficits. To fill their fiscal deficits. Fiscal deficits. These grants are given on the recommendations of Finance Commission. This truth is not told by the media. These grants are given on the recommendations of Finance Commission. But some vested interest and mainstream media, they distort the fact. They show as if these grants are given solely in the discretion of union government. No, not at all. They are given purely based on the recommendations of Finance Commission. The parameters to devolve these grants are the availability of per capita consumption of basic services in states, such as per capita availability of safe drinking water, per capita availability of education, per capita availability of health, per capita availability of roads and other basic amenities. My brothers and sisters in the states Jharkhand, Uttar Pradesh, Bihar, Madhya Pradesh, Orissa, northeastern states, Himachal Pradesh, Rajasthan, they are deprived of these basic amenities. Hence, Finance Commission on these parameters recommends at what share these grants can be given by the union government to states. 11th Finance Commission, 12th Finance Commission, 13th Finance Commission, they enunciated such grants cannot be given not just based on tax collection in that particular state, but on the parameters such as per capita availability of basic services such as education, health, sanitation, electricity, safe drinking water, roads, etc. Thank you, sir. Thank you. So this is Article 275. This is Article 275. Certain share of central taxes to states under under alternate scheme of devolution. It is a typing mistake. Please excuse me. Overnight, my assistant typed. There was some typing mistakes because of short span of notice. Certain share of central taxes to states under alternate scheme of devolution. Alternate scheme of devolution are given under. Good afternoon, Rohit. Good afternoon. Yeah. Certain share of central taxes to states under alternate scheme of devolution are given under. What is the right answer? Exactly correct. So 10th Finance Commission recommended 29% of central taxes. Now it is 41. 29% of central taxes. 29% of central taxes such as income tax. Actually, these taxes exclusively belong to union government. Income tax, corporate tax, income tax, corporate tax, customs duty, etc. 10th Finance Commission, it's recommended that this is alternate scheme of devolution. 10th Finance Commission, what it recommended, that is alternate scheme of devolution should be given to states. So 88th Constitutional Amendment Act has been effectuated. To enforce the alternate scheme of devolution. alternate scheme of devolution. So these are given on the vertical and horizontal distribution of these grants. These grants are given on the recommendations of Finance Commission. Given on the recommendations of Finance Commission. But mainstream media, it hides the fact. mainstream media जो है ये जो क्या बोलते हैं ये तथ्य जो है इसको छुपा के रखती है. Mainstream media hides this fact. Not only hides, it distorts the fact. Always I am cautioning you, my dear aspirants, the constitutional facts that are most probably distorted by mainstream media, distorted and twisted by mainstream media, definitely there are lots of chances that such constitutional facts will be asked in the exam. So President issues notification. President issues notification in this regard. Notification. Then he issues notification. Then it is approved by Parliament. Approved by Parliament. What is vertical distribution? Vertical distribution here means this 41% is vertical distribution. Then what is horizontal? Horizontal means between the states. Between the states. So how much should be given by the union? For instance, 1,000 crores have been collected under income tax. Out of these 1,000 crores, for instance, 41%. That means 401 crore should be given to states. In these 401 crore, how much should be given to Bihar? How much should be given to Telangana? How much should be given to Uttar Pradesh? How much should be given to Orissa? How much should be given to Karnataka? How much should be given to Tamil Nadu? How much should be given to Punjab? How much should be given to Jharkhand? How much should be given to Madhya Pradesh? They are determined by Finance Commission, which is a constitutional body. The chairman and members of Finance Commission, they visit every state. They extensively hold talks with the chief minister, ministers, the finance minister of the state concerned, the finance experts and other experts in the state. Then it formulates the parameters and principles based on which the union government devolves these funds to the states. But these are not discussed by mainstream media, and this fact is not given in any source, any material. Even in old Rajendra Nagar and Mukherjee Nagar in Delhi, आप छप्पा छप्पा चांद मारिए, आपको नहीं मिलेगा. And there are some intelligent people. They are so intelligent. यशस्वी, तेजस्वी, बुद्धिमान. ये बोलते हैं, why we should accept Finance Commission recommendations? Finance Commission recommendations are only recommendatory. Why the Union government has to accept Finance Commission recommendation? Are Babu Bayad, akal ke ande. When you do not accept Finance Commission's recommendations, first of all, why we should accept this alternate scheme of devolution? When you do not accept the recommendations of Finance Commission, then at the first place, the alternate scheme of devolution itself should not be accepted by Union government. No. They argue in such a manner that there will not be any logic in that. But anyhow, you forget about those vested interests. We are solely concerned with UPSC. I repeat again, we are solely concerned with passing the prelims, getting very good marks in mains. And why we are discussing these minute and latent facts in the Constitution? Because these constitutional truths, these constitutional facts, they are distorted and twisted by mainstream media. And unfortunately, these constitutional truths are not available in any source, even in old Rajendra Nagar and Mukherjee Nagar. So this is the alternate scheme of devolution. This is the alternate scheme of devolution. Then 23, the question number 23, under which one among the following articles the president can bestow such powers on the governor which are not given by the Constitution under any emergency or contingency? This is also not available in any source. You can check in old Rajendra Nagar and Mukherjee Nagar. What is the answer for this question? What is the answer for this question? What is the answer for this question? Anyone? Prakash ji. The answer is 160. It is one of the penal provisions of the Constitution. The President of India can bestow such powers on the governor which are not given by the Constitution under Chapter 3 of Part 6. In any emergency or in any contingency, with regard to such powers and functions which have been bestowed upon by the President on the governor, under Article 160, the governor acts in her discretion or his discretion, not on the advice of Council of Ministers headed by the Chief Minister. No. This article is very, very important and very, very penal. What I am saying, what does this article say? the powers which are not given by the Constitution to the governor. That means the police, law and order administration will be in the hands of Home Minister or the state government. Governor is only nominal executive. But in emergency or in any contingency, the President under Article 160 can bestow such powers on the governor which are not given by the Constitution to the governor in any emergency or in any contingency. For instance, if you take, for instance, just for our understanding, hypothetical situation, just as an example, recently there were communal riots in Murshidabad district in West Bengal last month. Yesterday itself, the High Court of West Bengal, it released its investigation report. So in such cases wherein public order is getting worse and worse, in such emergency or contingency, under Article 160, the President can bestow public order or law and order upon the governor under Article 160 in such emergency. With regard to those functions which are given by the President under Article 160 on the governor, governor acts in his discretion or her discretion. Governor acts in his discretion or her discretion. So is it clear? Is it clear now? Is the question clear? So this is Article 160. Under which one among the following articles martial law can be imposed? Under which one among the following articles martial law can be imposed? Under which one among the following articles martial law can be imposed? What is the right answer for this question? Article 34 is the right answer. Under Article 34, martial law can be imposed. Under Article 34, martial law can be imposed. Martial law can be imposed. Which one of the following statements is wrong with regard to martial law? What is the right answer? Martial law does not require the approval of Parliament for its imposition and its continuance. During martial law, civil administration and civil courts are suspended. Martial law can only be imposed by the President's proclamation. Martial law can be imposed in particular part of the country. Which one is right? Here the question is, which one is right statement? Right statement with regard to the imposition of martial law. Yeah, which one is the right answer? The right answer is this one. Many aspirants, they get confused themselves. That is why in Nirnay IAS we emphasize upon conceptual clarity, explaining the philosophy behind the concepts, incorporating deep insights amongst the aspirants. Many aspirants, they get confused with regard to national emergency on one hand, martial law on the other hand. They do not know the precise differences between national emergency and martial law. They mistake the features of national emergency as martial law. They mistake the features of martial law as national emergency. First and foremost glaring difference between national emergency on one hand, martial law on the other is, during national emergency, civilian administration, civil courts do continue to work. That means district SP, district collector, they continue to work. District courts, sessions court, metropolitan court, all these courts, they do function. And civil administration, district collector, district SP do function. But during martial law, no district SP, no district collector, only the military officer, colonel or brigadier or lieutenant colonel will be working as district collector and district SP. No civil courts, no district court, no sessions court, only military courts operating on military laws. No BNS, no BNSS, and no Bharatiya Saksha Adhiniyam, no Bharatiya Saksha Adhiniyam, no BNS, Bharatiya Nagarik Samhita, or no BNSS. Purely military courts will be operating on military laws. Second, but during national emergency, district collector, district SP, they do continue. District courts, sessions court will be functioning on BNS, BNSS and Bharatiya Saksha Adhiniyam. Second major difference between national emergency on one hand, martial law on the other. National emergency requires president's proclamation. That means president under her warrant and seal should issue the proclamation announcing national emergency on the written recommendation of the cabinet. But martial law can be issued by government GO. That means a joint secretary level officer in Ministry of Home Affairs, Union Ministry of Home Affairs, by issuing government notification can impose martial law. Third, national emergency requires the approval of the parliament within 1 month. The imposition of national emergency should be approved by both the houses of parliament with special majority within 1 month from the date of imposition of national emergency. But martial law doesn't require any parliament approval. National emergency can be imposed throughout the country or in particular part of the country. Martial law can be imposed only in particular part of the country. So these are the differences between national emergency and president rule. But in most of the sources, these minute details are not taught. They are not taught. By which amendment act of constitution national emergency can be imposed in particular part of the country? What is the right answer for this question? Which one of the following, by which amendment of act of the constitution national emergency can be imposed in particular part of the country? What is the right answer for this? The right answer is 42nd Constitutional Amendment Act. The right answer is 42nd Constitutional Amendment Act. 42nd Constitutional Amendment Act. Then which one of the following statement is correct about district planning committee? Very minute fact, which is very, very important. Which one of the following statement is correct about district planning committee? Yeah, very, very important question, very tricky question, very tricky question. Yeah, anybody? This is not all the members. It is 4/5 members. So D is correct. 4/5 members are elected by members of panchayats and municipalities. This is correct. This is correct. Next question. Which one among the following is not correct about Metropolitan Planning Committee? Which one is not correct about Metropolitan Planning Committee? Yeah. Anybody? Anyone? This is the answer. This is the answer for the question number 28. This is the answer for question number 28. Question number 29. Which one among the following is a totally nominated body? Port Trust. Port Trust. Town Area Committee, Notified Area Committee, Cantonment Board. Which one is the right answer? The right answer is Notified Area Committee. The right answer is Notified Area Committee. The right answer is Notified Area Committee. Question number 38. The CEO of Cantonment Board belongs to IAS or Indian Audit and Account Service or Indian Defence Estate Service or Indian Information Service. The right answer is IDES, Indian Defence Estate Service. Indian Defence Estate Services. Which one among the following is created by a law made by Parliament? Municipal Corporation in a state, Town Area Committee, Port Trust or Notified Area Committee? Any one of you? The right answer is Port Trust. The right answer is Port Trust. The chairman of Cantonment Board is elected or nominated or is an IAS or the commanding officer of military station. Who is the chairman of a Cantonment Board? Who will be the chairman of Cantonment Board?